Here's our 10:30 docket.
Thank you, Mr. Shima. I now ask the attorneys in 124611, State of Kansas versus David Moeller to please come forward.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of David Moeller. And I would like to pause right at the beginning to say I am representing David Moeller. And notwithstanding the district court and the Court of Appeals finding that Mr. Moeller is deceased, I still understand that I have legal and ethical obligations to represent Mr. Moeller. That's what I've done through this proceeding. That's what I'm doing today. It's my understanding of my responsibilities.
And do you have that authority? I guess that my question is, we view this as an agency relationship, which typically agency relationships terminate upon death. And I think we have some case law that suggests that. And to me, maybe that's the biggest hangup with the Hollister approach, is that who then has authority to push this thing forward?
So I'm certainly still subject to a court order, I believe. I mean, my office was appointed to represent
I'm not
Mr.
suggesting,
Moeller.
I'm not questioning yours. I'm just more your continued representation. I'm
Yeah.
just more theoretically, from a legal perspective, under our abatement doctrine, it seems like absent a procedure to substitution, there's nobody left here to carry the bag, so to speak.
So I guess my answer is twofold, Justice Wall. One is, I'm still subject to a court order. And so, that's where I believe I have legal obligations continuing. And yes, and in fact, it's interesting to me, and as I brought up in my supplemental briefing here, the idea of there could be the possibility of some sort of substitution. That's what the Hawaii Supreme Court's done. That's what the Ohio Supreme Court has done. And in those situations, for example, then those courts have said, we'll find somebody, and it could be the defense attorney. And when I sort of read those, I thought, oh, you know what? That's what we used to do before Hollister, effectively, as a practical matter. And in fact, it's what we still do under Hollister, effectively. That even if there is a finding that a client of ours has died, that we continue to represent them until we are told we don't have a case any longer. That could change if this court adopted abatement ad initio. That might change those things. Or if there was substitution, and for the reasons I set out in my supplemental brief, I think that is an option for the court, because there are Kansas laws that provide for substitution of parties in court cases. And generally speaking, those rules of civil procedure apply on appeals, and in fact, apply in criminal appeals unless there's something. So to me, it was sort of interesting as I was sort of getting ready for supplemental briefing, because I've thought for a long time that the effect of substitution is an elegant solution here, as opposed to sort of the categorical, it's all or nothing approaches of abatement, ab initio, or non-abatement, pre-Hollister. The idea of sort of having more of a case-by-case approach to this, to say, state, do you feel like this is a conviction that we need to have still in existence? And if the state says yes, then you go, okay, then we should have an appeal of it and find out whether it was lawfully entered.
I inferred that you had an objection to filing a suggestion of death on the record, which generally in civil cases is what triggers the substitution process. I didn't understand that. I didn't think. Can you enlighten me?
Sure. And Your Honor, I'll say this, by the way, is tailoring into, because I understand I'm asking this court to revisit Hollister. And in order to do that, I have to explain why Hollister is bad. And this is in fact part of that. It's because I feel like it puts me into an adverse position with my client if I sort of have these obligations to bring up adverse facts as it relates to my client's appeal. So under Hollister, as I understand it, now, and this is what crystallized for me a little bit, even just during this preparation, is that the fact of a client's death now becomes adverse to their appeal. That wasn't true before Hollister.
But it could also mean that if there is nullification ab initio, would be very, very good for your client.
That's right. If this court adopted abatement ab initio or even substitution, then it's not an adverse. It could only be good for my client in that it could result in the vacatur of the conviction. But under Hollister, it becomes an adverse fact to my client. My colleague has, in his supplemental brief, sort of talked about, it's just death. That's just a fact. It's just a fact. Like it's not something else. And I tend to agree, it's a fact. It's just that under Hollister, it becomes an adverse fact to my client's appeal. And I use the example in my supplemental brief of Rayburn, where I came to this court and unsuccessfully urged this court to abandon the forfeiture by wrong of the fugitive disentitlement rule. But this court understood that, well, the burden is still on the state. If the fugitive disentitlement rule is going to apply, the burden is on the state to show that the factual circumstances apply that would cause that to be implemented. And but under the Court of Appeals and the state's proceeding here, the state could file a copy of Casper saying, looks like this guy's a fugitive, and this court has said, well, that's not evidence. But the Court of Appeals could say, well, counsel, we want you to investigate this and determine whether or not your client is a fugitive and report that back to us.
That strikes me as an issue with the Court of Appeals order, not Hollister. I mean, Hollister doesn't mandate that process. So in terms of a stare decisis analysis, I'm not so sure how that weighs into that.
If the Court of Appeals, and you clearly said the Court of Appeals is wrong in the way it's proceeding in these cases, then that might be right, Your Honor, that would be less persuasive as far as the stare decisis.
And then under the Rule 1.16, it looks like comment 23 kind of walks counsel through what you do. You have two options. You can assert privilege, litigate it, and then if the ruling is adverse, you can then appeal from that order, or you can then disclose the information that you were challenging. And I don't believe you asserted privilege in response to the order, did you?
In response to the order, no. I mean, I argued that it wasn't my burden of proof. And so, and I mean, I think that's wrapped up in that, Your Honor, the idea that it's not my job, or really not even an appropriate question for the Court of Appeals. The underlying basis of that, in part, not in total, but in part, is based on confidentiality. The second part of it, I'll come back then, Justice Wall, because I mean, if you agreed with me that the Hollister, the way the Court of Appeals is applying Hollister is incorrect as far as the burden of proof, I would still argue that this court should revisit Hollister. This court recently, as recently as wrote in 2020, said that the mootness doctrine is a prudential doctrine based on saving judicial resources and on appeal. And I would note to you that Hollister actually does the exact opposite. For example, let's use this hypothetical. I've been appointed on a case, very typical. I've docketed the case, and then I get some information that my client may have passed away. What do I do? Well, again, assuming Hollister, the way the Court of Appeal, I'm not gonna do anything. I'm gonna still have to get transcripts and pay for them. I'm still gonna write a brief with all the issues. Here's the only possible difference is I'm gonna be sure I raise a sufficiency issue now, because Hollister says that may be the only thing that causes my client to have their appeal survive. So maybe I file a sufficiency issue that I wouldn't have otherwise, but I'm gonna file the same brief. And the state's gonna have to file a response brief, because at that stage, we don't even know what the issues are in the case. It's not gonna stop that process. It's still causing us to expend all of the resources from the attorney standpoint on the front end for a case that, as we see in Cada, as we see in Baker, then just gets dismissed. We never get a resolution of the issues raised in that case. That's wasteful. That's wasteful.
I
And
understand. Go ahead.
Sorry. Your hypothetical just sort of, I mean, it is an interesting circumstance, and appellate work is a unique kind of lawyering. So I understand all of that, but even just the way you framed the hypothetical just strikes me that it raises the obvious question of, shouldn't a lawyer know whether his client is alive or not? And doesn't the lawyer-client relationship sort of demand that you know that? And your entire hypothetical is based on the fact that appellate lawyers have no idea whether their clients are alive or not.
I wouldn't go that far, Your Honor. So first of all, I'm appointed, so even the Court of Appeals recognized that it's not necessarily the case that I always know where my client is or what the status of my client is. And
And I was trying to recognize that with my comment about the uniqueness
Yeah.
of your role, but just as a baseline assumption, doesn't that seem faulty to the attorney-client relationship?
that I might not know whether my client is alive or dead.
Right.
No, I mean, I'm appointed by the court to represent a person. There are any number of circumstances where I may not know if my client is alive or not. And in fact,
It just seems odd to me, I guess.
Uh,
Maybe it's
yeah,
correct.
and
but
maybe it's a distinction between, and it kind of goes back to Justice Wall's question of, I mean, is there a difference if I'm retained, right? And I'm an attorney by contract, and that might be different, but I'm not. I'm appointed by the court. And so the answer is no. And now, am I interested in that question? Yeah. If I get information that my client might be deceased, am I doing something about that to check? As a lawyer, do I think I have an obligation to do that? Yes. That's different than, do I have to disclose adverse facts and things like that?
Along with the way you've answered my questions, it would follow that your position is that you have, as an appointed attorney, you have no obligation to attempt to talk to your client.
No, that's not correct. I understand that as an attorney, I have continuing duties of, for example, communication. That's a duty every lawyer has with their client. And so I always have a duty to try to contact and be in communication with my client. I'm just saying, as appointed counsel, that's not always possible.
Okay.
The Court of Appeals seems to not recognize that.
Practically speaking, it seems like maybe we've had a handful of these types of cases since we went to this sort of modified approach. It doesn't strike me that it's been difficult to administer, or, the more good than harm sort of argument in the stare decisis analysis. What's your pitch there?
Yeah, so it depends on where, from my standpoint, it's been very difficult. And I've now had, I should clarify, the Court of Appeals, I don't know if they were kindly or, talking about this is a recurrent issue with the Kansas Appellate Defender Office. No, they're citing my cases, right? It's not, I don't get to speak on behalf of the Kansas Appellate Defender Office. I'm not today. So I disagree with that. And certainly this waste of resources is true. And it's less important, ironically, but it's also leaving illegal judgments in place, illegally obtained judgments. And that's a harm that's associated with the Hollister, as opposed to if this court adopted abatement ab initio or substitution, all of these problems would be solved. All of them would be solved because either the conviction goes away, my client's happy, I'm done. I could get rid of that case at docketing, or we have the appeal and we decide whether or not it's a valid conviction.
What happens, sorry. What happens to restitution ab initio?
It would go away. Restitution in a criminal case, if it's criminal restitution, there has to be a valid judgment on which that restitution judgment is based. If it goes away ab initio, the restitution judgment goes away. And that's, at that point, we don't have to worry about were there any instructional errors, were there any evidentiary errors.
But what I'm saying is, doesn't that do harm to a victim? Because wouldn't it be, if there was a restitution in place, wouldn't the state have to pay for it?
Would the state have to pay? I'm not sure what you mean by the state.
The estate.
The estate. Maybe if the victim, files a civil suit or something like that. But that's, and by the way, I would respectfully, in my opinion, respectfully, I think Hollister is conflating the issue of mootness with the issue of remedy. And I think that goes to some extent to your question, Justice Standridge, that what happens after this court would do what it always does in every other appeal, that's a separate issue, right? That doesn't have to do with mootness. Here's the thing. It seems to me that the underlying conviction is moot or it's not moot. If the underlying conviction is not moot, then the appeal's not moot because this court can do something about that conviction. It can reverse it. If that underlying conviction is moot, then I don't understand why abatement ab initio isn't the right approach. It would save judicial resources. It would correct all these problems, get these cases out at the earliest point. Oddly, my colleague and I seem to agree that like these convictions aren't murders. I mean, that seems to be my colleague's position on this, maybe because of restitution, maybe because of the emotional impact of these convictions. If that's true, that's fine, but then we should have the appeal like every other case.
But how do you get over the procedural hurdle? I mean, I think I can agree with you there, but it's like, you know, in a civil matter, you do, as Justice Wall says, you can substitute a party. Who wants to substitute for a defendant? You know,
I
how does
can't-
that happen?
I mean, that's what, and that, for me, that was the news when I read the Hawaii and Ohio. The Kansas Appellate Defender Office can if it's an appointed case,
But then.
which is in effect what we did before Hollister.
What do you do about remedy then? Because the Kansas Appellate Defender Office doesn't want to be responsible for the restitution and costs.
Yeah, as I understand, go ahead, Aaron.
And, you know, and if you do get to that stage, we are talking about a substitution. Because for the state to go back against the estate, there's gonna have to be an estate. So I agree with you that there seems to be a line that we should perhaps be drawing when we think about conviction separately from the remedy in that regard. But, so how would we deal with that?
So, I mean, I think when we talk about substitution, it's just, as I understand it, under the Hawaii and Ohio Supreme Court decisions, it's who gets to make decisions. It's not like the Kansas Appellate Defender Office becomes liable for restitution or that I might go to prison or, you know, that's not what, it's just who is the person that makes the decisions in this case now. And what was interesting to me was like, oh, it might be next of kin, but it could be the appointed attorney.
But actually, in the civil context, it's the question of who's the real party in interest in terms of liability. And that's why substitution usually is maybe by a personal representative, but if essentially the estate.
But in a criminal context, I don't know that I mean, I think that's what the Hawaii and Ohio Supreme Court are saying is it's really just the decision-making part of this. And that in those cases, but I mean, again, that's because I practiced a long time and I practiced a long time before Hollis. And I had cases where clients died. And it turns out, I mean, nothing's different. I know exactly what to do. I know exactly what my client wanted.
But it is that substantive difference that makes me concerned that the civil procedure doesn't really apply. It's not a perfect fit here.
Well, you know your code better than I'm gonna talk to you about the civil procedure code. But to the extent that that's true, again, and I sort of made this in a footnote in my supplemental brief, this court could adopt a new procedure. I mean, this court has the inherent power under its own constitutional authority to make rules of appellate procedure. So to the extent that this, you know, you would think it's different, but you like substitution, you just don't think it fits within the civil rules, this court could pass a rule affecting it. There's nothing stopping you.
And that would be through our ordinary rulemaking processes with notice and public input and comment, not judicial opinion.
Well, I guess, I mean, you make rules through judicial opinions like Hollister and cases like that, so. Your Honor, I'm over my time. I keep talking, but thank you.
May it please the court, Chris Elsliger appearing on behalf of the state. The state's position is that Hollister strikes the right balance between the competing interests of the state and the defendant. It maintains an opportunity for the defendant to try to clear his name, but at the same time allows for the state to pursue its interest in getting issues of statewide importance clarified and ensuring that a valid conviction remains on the books and that the victims have proper closure for their injuries and that restitution remains in place. And that's essentially my argument. The issue of substitution, well, I will tell you, it seems like another reasonable alternative. I think though it's not necessarily, I don't know that it has any advantages over Hollister other than because it would keep the same interest in place, but it would also allow for truly moot issues to be brought to the court, which I'm not sure that there's any reason for that.
Piggybacking on Justice Wall's real party and interest comment.
Say that again?
I'm trying to piggyback on Justice Wall's comment about the real party and interest. In other words, that being the conceptual idea behind civil substitution. is who's the real party in interest. Does that carry over into criminal law? In other words, I find the whole notion of substitution in criminal law to not work for the reason your opposing counsel pointed out, which is, look, I may be substituted, but I'm not going to prison.
Well, first off, I don't think I'm as smart as you think I am. Let me think about that a moment. Yeah, I mean, it doesn't carry over exactly. I think it's,
I mean,
as Luther
I'll just
pointed
put it
out.
bluntly. How can someone substitute themselves in a criminal case without putting themselves at jeopardy of going to prison?
Well, keep in mind, I'm not advocating for substitution. I'm just saying, I listened to his argument. I don't think it's necessarily
But you-
unreasonable
you-
one,
you-
but
I mean, the reason I started asking my questions is because you said, what I heard you say at least is substitution seems reasonable to you.
yeah, I mean, if there's some way to do it, I mean, and I don't know who you would put in there, maybe the estate. I don't know. What
But
the
I
state
guess
doesn't
the
want.
point is criminal liability is so intimately connected with the person.
Right.
It is not something that can be easily divorced from the person and placed onto some other party, like various civil
Oh,
obligations can be.
I agree. And I think you'd have to look back at the reasoning of the Hawaii courts and the other courts that adopted substitution. But, and I think maybe they had some kind of actual statutory procedure or something for that. I don't recall those cases. I'm telling you, I'm not advocating for it. I think the Hollister decision is fine. The state's okay with that. And as I made clear, I think in the supplemental brief, what the state doesn't like is the idea of abatement, because that washes away a valid criminal conviction, for no reason other than an accident of fate.
But it doesn't find them innocent.
I'm sorry.
It doesn't find them innocent.
Well, I think it just
Because
simply
they're-
vacates.
Your journey isn't over yet. I mean, we don't find them innocent even if we reverse, they're in a situation where they have to try it again and they may lose again.
Right, but the abatement just vacates, my understanding of abatement is it vacates the
Vacates the
The
conviction
conviction.
and drops the charges.
Right. Which,
But it doesn't find them innocent.
The reality is there still is a free finding. I mean, I understand, I mean, I understand that, wanting that process for the victim, but the process has happened. There was a jury verdict. It's really a technicality. And we talk about technicalities all the time, but there still was that finding.
but why not just leave it
So
in
what
place?
more?
I mean, I don't understand. I honestly don't understand why we would abate it if there's been a finding beyond a reasonable doubt. But the bigger concern, I think, really, the real practical concern is the restitution order. Like in this case, this victim was ripped off about $10,000. And, as I don't know if there's money in the estate. I know, I don't know anything beyond that, but let's just assume that there is money in the estate that could pay that restitution. If the restitution order goes away, then yeah, sure, the victim, I guess, could pursue a civil suit, but that's hiring a lawyer and going through the whole process again when there's already a valid restitution order in place.
Well, they could
But you have
just,
to have due process. I mean, I know I'm asking questions out of both sides of my mouth, of course, but you do have to have due process, before you can get to that stage of enforcing a judgment. There has to have had that process. And why, and who is left for, the payment of that restitution? Unless you do the substitution, and that gets back into that loop of who do you substitute? Frankly, it just seems like, there are hurdles at every stage of, I'm not sure there is, I think the word that Hoskinson used, an elegant solution. I don't think there is an elegant solution to this problem.
Oh, I would agree with that. That's why I think Hollister just kind of struck the right balance for a difficult situation, because it does allow each side to still pursue those interests that are still alive. Like if the
And what
defendant
is-
wants to clear his name, he has that option. If the state believes there's some, issue of statewide importance or real controversy, or perhaps the restitution order the state wants that to remain in place, Hollister gives us that option. I think.
What is the purpose of the restitution order, since it is now no longer a civil judgment?
Well, it's again to to repair the damage to the victim done by the defendant's criminal act.
No defendant left to pay.
But he still may have assets or, whatever.
You have to open an estate to get to that. You can't make a claim against a decedent without an estate, can you?
Okay, I will admit that
Under
I-
Hollister, let's just take that hypothetical, if it is litigated and you have a final judgment under a Hollister type appeal, at least that has preclusive effect in terms of liability, would it not? Even if the victims wanted to bring a civil suit against the estate.
yes, I'd agree with that. If I understand what you're saying, and I have to admit, I don't do civil practice. I don't do estates. I learned that stuff in law school, but that was like 25 years ago. So the mechanics of that are a little bit over my head at this point. If there is a process though for that to happen, I think having the opportunity to keep the conviction in place and that restitution order in place, I think is important, even if the victim has to then go to civil court and say, hey, I want my restitution. At least you've got that order from the criminal case that shows the liability. And I think that would at least, again, vindicate the victim's rights, because
Can it when we're only looking at sufficiency on appeal under Hollister? If a defendant has raised 8 issues, one of which is a sufficiency, and under Hollister, we're going to look at the sufficiency. We're going to look for actual innocence. But that doesn't mean that there was a valid jury verdict. There may have been errors that would lead a court to have overcome, reversed that jury verdict. So I really do question that judgment does have preclusive effect. If there are legal issues that are unresolved that attack the verdict.
Well, I mean, the other option, of course, is, and I think my colleague would agree, we could just leave, just allow the appeal to continue even past the death of the defendant, to let those issues.
What happens
but-
if one of those issues warrants a remand?
Well, then
retrial.
therein lies the problem, because then it really is a moot issue, because there can't be a retrial because the defendant is dead. And this is the problem. I mean, that we're wrestling with this. Why, like I said, I think Hollister just kind of struck a balance. It's not perfect. It's not elegant, to use Randall's phrase there, but I'm not sure that there's not any solution to this that really would make everyone happy. I think Hollister kind of, splits the baby in a way that we can all sort of agree with.
Well, one other option we haven't really talked much about is the other side of the balance, which is why isn't the whole thing moot?
Well, again, as I pointed out, I mean, the state has interests in ensuring that a jury verdict stands and that the victims get
Well, I'm not talking about
proper vindication for their
void. I'm
injuries.
talking about just that it's moot. I mean, I understand that you object to the
Well,
remedy of voiding the whole thing.
I mean, if you declare it moot, but just don't, but leave the conviction in place, I'm fine with that. I think that the state's fine with that.
That is my question.
Yeah, I mean, I think that also is the only option that the state is really opposed to is just complete abatement. If you just rule the case as moot and the conviction and
I mean,
restitution
let me give
stays
you
in
another
place.
hypothetical. I don't know. I presume this probably has happened from time to time, but you proceed to trial on a first-degree murder charge, let's say. You get a guilty verdict. The court sets a sentencing hearing a month later, and between the verdict and the sentencing, the defendant dies. What happens?
I don't know. Obviously, you can't sentence him because he's
Right.
dead.
I mean, it just moots the whole thing. I mean,
Yeah.
doesn't it? But the conviction is still there.
I suppose in that unique circumstance, that would be,
How is this any different?
well, in this case,
I mean, I
we've gone,
guess that I
we-
get that it's
we've gone through
procedural.
that first phase. That first phase is done. You have the valid.
conceptually, is there any difference?
Well, I think conceptually there is, because we've got through those procedural steps. There is a valid sentence in place. There is a valid conviction in place, and we're on appeal.
But
I mean, how's it?
isn't that a presumption, though? That the conviction was valid? I mean, what if it was a complete sham? That, not that I would never suggest that happened in this case, but what if it happened? That they planted evidence and it was, witnesses lied and it was a complete sham of a conviction. And that is appealed. Where's the justice there if we just leave that in place with
Well-
horrible errors?
And that's why I think ultimately the Hollister decision strikes the right balance, because in that kind of situation, the defendant would have the opportunity to vindicate his rights, even though he's passed away, and point that all out. I do want to, if I can, return back to here. I mean, the other way, I mean, we do look at this differently too. Let's say we've got through the appeal process and they file a 1507 and they die. Well, we don't go all the way back and vacate. So there is some meaning to the procedural steps being crossed, I guess is my only answer to that. Although I admit conceptually that's a difficult hypothetical for me. I get that. And again, I don't think there is a nice, elegant answer. I think, the court struck the right balance with Hollister, and I don't think my opposing counsel here has given the court a real compelling, persuasive reason to just abandon Hollister. Hollister so far has worked for what it can do. And the state would ask the court to just go ahead and affirm Hollister. There's no reason to go down another path and try another, maybe another dead end. I don't know. I just think we got a system in place. The court obviously reasoned it through in Hollister, and I would just ask the court to affirm it.
Yeah, this is just, seems, this was argued in, Hollister was 2014. And this seems almost like a deja vu to that argument. It's how do you strike a balance between the defendant's, appellant's interest in exoneration versus yours and accountability to save. And the part that I didn't, well, I shouldn't say we didn't, but the Mr. Hodgkinson's issue with who makes the decisions in the case. What's your thinking about that? He has a client that's dead. He's acting as an advocate, but ultimately, isn't it the client that makes the decisions on how to proceed?
Well, I think in theory, yes, although as I think Mr. Hodgkinson kind of pointed out in his argument, that when it comes to appellate practice, the clients, I don't think are particularly involved most of the time. But yeah, I mean, if we're going to look at this purely in theory, yeah, the client should be making the call. And if the client's not there, then the only thing the attorney can do as his advocate is look at, well, what is in the client's best interest, as Mr. Hodgkinson has made clear. And certainly, I think we can all probably agree that, at least intuitively, that anyone who's been convicted of a crime will at least want to try to clear their name. So at least that much would continue, which is what Hollister, I think, was all about, was that the defendant should still have a chance to clear his name. And at the same time, if there are issues of statewide importance, we should have an avenue to get those heard so they don't just, continue to fester.
Should we be thinking about an amendment to Rule 2042 that requires the state to give notice of this as if it was a custodial change?
Well, that opens up a can of worms.
Right now,
Yeah.
right now that rule applies only to sentencing appeals. I think there's a strong argument that could be made that limitation should be it should just apply to appeals generally. We see a number of cases where, just looking at the sentencing journal entry, it looks like the person has served their convictions, and there are other things that sometimes you go, why do we not have a change of custodial status and we're not seeing it?
Well,
Anyway, your thoughts about adding death to that rule?
well, I think that here's the problem. The problem with the rule as it is, I mean, the state would really appreciate if just the parties were responsible, because here's the thing, we don't know, the DOC doesn't tell us when somebody gets released and like that. We don't have any, sitting in our office or any county attorney's office, the only way we can check to see if somebody is in custody or not, we get on Casper just like anybody does and look and say, oh, it looks like he's still in custody. Okay, let's hope that doesn't change before oral argument, maybe check right before oral argument. Because we don't get any notification. Now, if it looks like he's out, or you look at the journal entry, he should be out, well, then we have to start making phone calls to find somebody who can tell us. And so like every time I find somebody at DOC who might have the answer, by the next time I call, that person has moved on, I got to find a new person. So it isn't, it's challenging. I mean, it's not an easy thing for us to do. And when it comes to somebody's death, that's even more difficult, because how am I gonna know if a person died? Unless, again, he's in custody. I look on Casper and it says he's deceased. Well, okay, I've got an indication there. So, I mean, it seemed like it would be more fair if it was just incumbent on the parties to, as part of their duty of candor to the tribunal, to inform the court if the defendant dies, so that either one of us can do that. And if it's a rule of the court, then that would ease, I think, Mr. Hodgkinson's concern about how he believes that that's adverse to his client. I don't agree with him, but I understand his point of view. But, attorneys are required to report things like, controlling case law is adverse to their interests. So, I mean, I'm not sure how this is, I mean, it's not as easy, it's not an exact analogy, but I mean, attorneys are required to report things to a court and to be candid and honest to a court. So if we're going to have a rule that we have to report that, it would be, I think, beneficial to put it on both parties to if either side gets an indication that the client is, or the defendant has died, to report that to the other side and to the court, so that we're not, we're not playing games, and we're not, just because as a practical matter, it just seems kind of like gamesmanship to try to say, well, I can't tell you if my client's dead or not. I mean, come on, he's dead. It's a fact. And the challenge of putting it on the state is it kind of assumes that we know more than we do. It is, in this particular case, it turns out I did find out actually from Randall at some point that this guy might have passed away, but that got lost in cyberspace. And so by the time when this came up on appeal, I got the show cause order from the Court of Appeals. I had no idea. I mean, I don't know. How am I supposed to know if he's dead? And so I had to go do some digging.
I follow you to a degree if the person isn't in custody, but
Right.
they're in state custody.
Right. In this case, he wasn't. I think he was, but you're right. Like I said, I mean, I would just get on Casper and look and say, well, is he deceased? Well, that would give me an indication. But if the guy's on probation or is, not in custody, it does become more challenging. So that's why I just say, just put it on both parties. Make us both have, follow our duty of candor to the court and tell the court if one side or the other has information. I just don't understand why it's all on why it would all be on the state's responsibility, because we're not clairvoyant either. It seems like if the opposing side has that kind of information, just let us all know. So, I mean, that's my rant on that. I mean, I kind of not sure I was really prepared for that question. Maybe I should have been, but that's what I can say on that. To circle back around to this issue, again, I'll just reiterate, I think that Hollister struck the right balance. I don't think there's any reason to stray from that. We should just continue to follow Hollister, and ask that you affirm the Court of Appeals if there are no further questions.
Your Honor, I just want to try to answer some of the questions. Justice Rosen, sort of on the question of who makes decisions and things like that. And it's clear the division of authority on an appeal. I mean, the client decides whether or not to appeal. And my client in every one of these cases decided to appeal. They filed a notice of appeal. And under the division of authority, I make all the rest of the decisions in the appeal. That's the division of authority when we deal with appeals in cases. And it's clear, I don't have to do everything my client tells me to do. I have to communicate with my client. I've taken into consideration my client's thing. If I have a client that I can communicate with, but I make those decisions anyway. And so that's why before Hollister, this wasn't even an issue. I mean, if the client died, I know what the client wanted, so it's not an issue. And I know what the client wants today. So that part of it. Justice Stiegel, I mean, I have looked a little bit at your question, and I think the answer is if a client dies between the time of verdict and sentencing, because final judgment in a criminal case is the oral pronouncement of sentencing, and the judge is not able to pronounce judgment. And so the case is dismissed because there is no way to pronounce judgment. You're stuck in that position. So there is no verdict because the only remedy in that situation is that. And that's, again, that's a remedy issue. It doesn't have anything to do with mootness. That's a separate point. Both to Chief Justice and a little bit to this question, I freely admit I don't necessarily understand all the nuances of civil substitution. It seems to me that as Hawaii and Ohio are interpreting it, and this is true. I mean, anybody can, I mean, you can have creditors substituted as a certain party or something like that. That's my understanding from reading these cases is how substitution works. Yeah, let's say I'm wrong about that. Okay, there is still the middle ground, which is, this is again, how we did it before, even before Hollister, is you just have non-abatement, but, you know, and this is in fact what I reached out to Chris to say, look, do you care about this anymore? Does the state care about this particular conviction anymore? Because if you'll agree to make it go away, the appeal can go away, right? I've done everything possible for my client if this conviction goes away. And so
What
maybe
does-
it's not
what- what-
substitution, maybe it's some other process.
What does it mean for a conviction to go away?
That it's vacated, that it's no longer a part of the public record, that that's not a judgment of the state of Kansas any longer.
Okay, so in your answer to my hypothetical a minute ago, you said the case would be dismissed.
Yes.
And I think I agree with that. Why wouldn't the same apply on appeal? In other words, we can look at a criminal case and there is a line between district court and appellate courts, and the line is a final judgment. But as a whole, we would not say a conviction was quote unquote final until the appellate process had been exhausted. For example, for the start of the time clock for collateral attacks, right? And you would agree with that. So why wouldn't we treat the entire criminal process as one?
So
And I guess I don't conceptually understand the difference between a defendant who dies between conviction and sentencing and a defendant who dies between sentencing and appeal.
no,
I don't understand.
I
the
think I
difference.
agree with you, Your Honor. I
So
mean,
why wouldn't the outcome just be to dismiss the appeal?
because it's still leaving the judgment in place.
Well, what does that even mean, though? That's what I don't
There's still a
understand.
district court judgment on the state of Kansas that my client is guilty of this crime.
Wouldn't that be true if the case was dismissed after conviction but prior to sentencing also?
No, that's what vacatur does. It says that's no longer a part of the
Well, you-
record and judgment of the state
So
of Kansas.
when you said that the case should be dismissed, you actually meant that the whole thing should be vacated.
Yes. And that's, I think, the right answer. And that's, I think, the dissection of the appeal from the underlying judgment, I think you're exactly, I mean, not trying to put your words in your mouth, but I think that's exactly right, that until there's been at least one review of that conviction, it's not a final conviction.
And I think I agree with that. I guess where I'm stumbling is this difference between dismissal versus vacating. I'm not sure that matters. Back to what Justice Luker said, like it actually happened. It's not as though you're gonna be Men in Black and erase everybody's memory
I
about
mean,
what
if
happened.
that's true, then why not adopt vacator?
Because it doesn't make sense. It doesn't, in other words, what the remedy is just to dismiss it. Why would you go back and vacate something? There's no reason to vacate.
Yeah, I mean, even my colleague, I think, is admitting that, like, if there's a restitution judgment out there, that's still something that they think is enforceable or could make a difference in the world. I'm not sure if my colleague is admitting that anytime there's a restitution judgment, at least a case isn't moot, even if the client dies. I'm not sure, but it would seem the logical conclusion. I mean, that conviction, here's the way to make sure that conviction has no further consequences. You vacate it.
Because there's an actual controversy existing though, right? Once the appeal continues. I mean, not every issue is moot once the appeal is started, right?
That's right.
Oh, okay.
Thank you for taking this case, Your Honor.
Thank you to both counsel for your arguments today.